Welcome back to U.S. Visa Portal, where we deliver essential updates on immigration policies and international travel regulations that impact millions around the globe. Today, we are addressing a matter of critical importance that is currently affecting a vast number of individuals, many of whom remain unaware of the shifts that have already been enacted. If you are viewing this, it is likely that you or a loved one possesses citizenship in multiple countries, perhaps acquired at birth through dual nationality or obtained via marriage naturalization, or even automatically for children born in foreign lands. Regardless of how this status was attained, the information we are about to discuss could profoundly alter your strategies for international movement. Your approaches to financial disclosures, and in certain tangible situations, it might influence your capacity to traverse borders without encountering unforeseen holdups, interrogations, or sanctions. As we progress further into 2026, a series of regulatory modifications has emerged that a significant portion of dual citizens has yet to comprehend fully. These are not mere conceptual debates confined to administrative halls, but rather operational enforceable mandates that are presently being applied at airports, frontier stations, and banking entities worldwide. Those finding themselves unprepared include regular voyagers, upright individuals who were simply uninformed that the guidelines had evolved subtly yet substantially. Prior to delving further into this dialogue, we urge you, if you appreciate precise, direct, evidence-driven coverage on matters of migration, rules entry permissions, global journey stipulations, and the international political shifts that affect your routine existence, to subscribe. Immediately activate alerts to ensure you receive every notification, and contribute a remark below indicating if you maintain dual nationality and whether these latest alterations have posed any difficulties for you. Moreover, if there are relatives, acquaintances, or professional contacts in your circle who could gain from grasping these developments, kindly disseminate this content to them without delay. Traditional news outlets are not delving into this with the necessary depth, and often the most affected parties are the final ones to become informed. To clarify from the outset, the regulatory adjustments rolled out across 2026 were not crafted to penalize those with multiple nationalities, nor to complicate existence or unjustly focus on newcomers. Their core purpose is to reinforce authentication mechanisms, enhance cross-border economic openness, and seal vulnerabilities that global administrations perceive as fostering security risks or facilitating deceitful practices. The issue arises, and this is where typical citizens suffer, when protocols intensify and oversight grows stricter as those earnestly attempting to comply. Those with no desire to err can nonetheless become entangled in administrative complexities merely due to a lack of knowledge regarding the new expectations. Consider it thus a lone overlooked document, a travel credential that fails to align precisely with details on an alternate identification, a voyage arranged without meticulously verifying the present entry criteria for the target nation. These may appear as trivial errors, minor lapses, but in this year such minor aspects are yielding major repercussions. Journeyers are confronting postponements at entry points, enduring unanticipated probes by frontier officials, and occasionally incurring monetary fines that were entirely preventable with prior awareness of what to monitor and what preparatory measures to implement. Our objective in guiding you through this is not to instill dread or unease, but to foster understanding. These modifications are influencing countless individuals who reside transnationally, labor overseas, pursue studies in foreign territories, or construct their prospects in plural nations. If you fall into this category, you merit a thorough comprehension of the obligations when they pertain to you and the actionable steps available presently to circumvent future complications. Therefore, remain composed, accompany us in this exploration, and we shall proceed methodically with poised lucidity and the essential facts to safeguard your interests. Before examining the particulars of novel disclosure mandates or the revised credential protocols now active, it is vital to lay a firm groundwork. In tangible, everyday contexts, what constitutes dual citizenship? Also termed dual nationality, it signifies legal acknowledgement as a national by two distinct states concurrently. This condition can arise through various paths. Certain individuals enter the world in one state with guardians possessing nationality in another, thereby inherently entitled to both from inception. Others wed citizens of other lands, and via that union secure nationality in the partner's homeland, while preserving their initial one. Some undergo official integration after prolonged residence and employment abroad, and contingent on their origin country statutes retain their primary nationality post-integration. Frequently, offspring arrive in overseas locations to parents holding nationality in one place, while the delivery occurs in another that bestows nationality by birth locale. From birth, these youngsters are dual nationals, sans any deliberate application. For the bulk of holders, dual citizenship represents a true benefit, facilitating smoother global transit due to greater passport options and visa exemptions, maintaining familial bonds across divides, upholding cultural roots and lineage, which holds profound significance for numerous households, and unlocking avenues in learning careers and enduring stability unavailable with singular nationality. Particularly in the United States, dual citizenship is broadly endorsed and affirmed. The American administration recognizes concurrent nationality elsewhere, without inherent forfeiture of U.S. status. Generally, no statute mandates selection between them. Yet complexity intensifies here, overwhelming many. Possession of nationality in two realms may entail adherence to dual legal duties. Two regimes might demand specific data from you. Two nations could enforce disparate regulations on travel papers, journey records, fiscal declarations, or conscription duties. These do not invariably harmonize and may clash outright. With technological progress and heightened data exchange via pacts and electronic frameworks, the apparatus monitoring global transit, validating identities, and overseeing economic clarity has grown increasingly linked and advanced. This underscores the relevance of 2026 revisions. They concern protection, anti-deception, ensuring document precision and full fiscal openness. However, as controls stiffen and checks heighten, those unfamiliar with contemporary norms may inadvertently generate grave issues absent malicious intent. An unreported form due to ignorance, an unexpectedly lapsed credential from overlooking the half-year validity, a foreign account undisclosed to revenue bodies assuming exemption. Such scenarios seldom stem from deliberate misconduct, but rather innocent unawareness. This is the void we aim to bridge today, highlighting why this knowledge is pivotal. Dual citizenship poses no inherent issue. Multiple passports are lawful in most cases. Crucial are consciousness, precision in records, and foremost integrity and openness with officials. If aspects confuse you, that is acceptable as migration statutes perplex even daily practitioners. Our aim is serene, clear guidance, sans undue alarm. Now consider a key domain demanding heightened vigilance for dual nationals reporting duties. Recently, worldwide governments, including the U.S., have bolstered mechanisms for fiscal openness and curbing international finance abuse. This targets fraud, laundering, evasion, and illicit cross-border fund shifts, not specifically dual holders or migrants. Yet tightened rules and vigorous enforcement can ensnare ordinary folk with simple finances due to misunderstanding reportables or triggers. Additionally, passport duration stipulations merit attention. Numerous states mandate validity extending 6 months past entry or exit intent. Carriers must verify pre-boarding, facing penalties for transporting inadmissibles. Thus, even with remaining months, sufficiency may falter under the rule viewed differently by agents or officers. Proactive renewal far ahead, especially with dual credentials and inter-use plans, is wiser than procrastination, averting most issues pre-check-in or counter. Another subtly evolved sector involves border security and biometric confirmations. Global passports integrate advanced safeguards, many with chips holding biometrics. Facial tech deploys at checkpoints, fingerprinting standardizes. These thwart fraud and theft, enhancing safety, security, and often speed via efficiency. You might observe automated units scanning faces, fingerprints, or chips over manual stamps. For most, this streamlines yet flags mismatches, inconsistencies, or discrepancies readily if names vary, birth dates misalign, or travel logs inconsistent across databases, prompting manual review. This signals no automatic guilt, often just verification that records match, legitimately explaining variances. Tech now detects minor mismatches prior systems overlooked, sometimes intimidating when screened. In such instances, composure and truthfulness are key. Respond succinctly. Display documents, explain factually, e.g., post-marriage name change, cultural name order, recent renewal number shift, common officer encounters. Now addressing conscription concerns alarming some duals. Not all mandate service, but some enforce for nationals extending to duals even non-residents or never resided if age eligible. Families often surprised offspring raised elsewhere minimally fluent, then discovering obligations visiting or renewing. Frightening, confusing, clashing with commitments. U.S. views dual status unproblematic, yet foreign military roles, especially command-sensitive amid tensions, may question loyalties or clearances rare but noteworthy. If secondary nation requires service, avoid panic or evasion contact. Embassy inquire requirements, ages exemptions. Many offer deferrals, waivers for abroad primaries or non-residents. Openness, proactive dialogue, safest. Now families and child-specific dual challenges. Often birth-initiated parents, unaware early record import. Overseas birth to U.S. parent may confer eligibility per residency, etc. Simultaneously, birthplace grants auto-nationality dual from day one unplanned. Issues emerge later lacking proof if unreported. To consulate sans confirmation barriers arise, passport applications, schooling travel identity proofs. Devastating discovering incomplete docs, not intentional but unknown importance. Awareness aids report promptly organize records passport early ensure consistent biodata shielding from future stress. If this aided clarity, we are pleased. Subscribe to U.S. Visa Portal for factual deep dives on policies, regulations, relations, global structures, common experiences, questions, share with duals benefiting. Thanks for time at U.S. Visa Portal. Rules shifted significantly. Not all know, but you do. Empowering protection, confidence. Stay informed, safe. See you next. To expand on these points, let us revisit the foundational aspects of dual citizenship in greater detail, as understanding its origins and implications is essential for navigating the current landscape effectively. Dual citizenship, as previously noted, arises from birth to parents of differing nationalities, where the child inherits both, or through marriage, where one spouse gains the other's nationality without losing their own, or via naturalization in a new country while retaining the original based on permissive laws, or for children born abroad in jurisdictions that confer citizenship by soil, right alongside parental transmission. This status offers advantages like visa-free travel, family unity, cultural preservation, educational and professional opportunities, and security options. In the U.S., it is accepted without mandatory renunciation. However, dual obligations can conflict in areas like taxation, military service, or documentation requirements exacerbated by interconnected global systems. The 2026 updates emphasize security and transparency, leading to potential pitfalls for the unaware, such as unreported finances, mismatched documents, or validity issues. Financial reporting has intensified to combat laundering and evasion, affecting duals with foreign accounts, requiring disclosures to avoid penalties. Passport validity often demands 6 months beyond stay enforced by airlines and borders, necessitating early renewal. Biometric advancements like chips, facial recognition, and fingerprints enhance security, but highlight discrepancies, prompting reviews where calm honesty resolves most. Military obligations in some countries apply to duals, requiring embassy consultation for exemptions. For children, early reporting and consistent documentation prevent future barriers. Overall awareness, preparation, and transparency mitigate risks, allowing dual citizens to benefit from their status without undue complications. Continuing this serious examination, let us further dissect the reporting requirements that have become a focal point for dual citizens in 2026. Governments worldwide have implemented stricter protocols for financial transparency, not to target dual nationals per se, but to address broader concerns of fraud, money laundering, tax evasion, and illicit fund transfers across borders. This means that individuals with bank accounts, investments, or other financial interests in multiple countries must now be vigilant about disclosing these to the appropriate authorities, often annually or upon certain triggers like income thresholds or account balances. Failure to report can result in audits, fines, or even restrictions on travel if linked to immigration status. For U.S. citizens, this includes compliance with FATCA and FBAR requirements, where foreign accounts over certain values must be declared to the IRS regardless of where one resides. Dual citizens might find themselves navigating similar rules in their other country of citizenship, which could have its own set of forms. deadlines and penalties creating a web of obligations that demand careful organization and possibly professional advice from accountants or lawyers familiar with international tax law. Turning to passport procedures, the 6-month validity rule is enforced by many nations, including those in the Schengen area parts of Asia and elsewhere, meaning that even if your passport expires in 7 months but your trip is in 1 month, it might not suffice if the requirement extends beyond your departure. This is particularly relevant for dual citizens who may use one passport for entry and another for exit, or have to align renewal timelines across different issuing authorities. Airlines facing fines for non-compliance will deny boarding if validity is insufficient, so checking destination-specific rules via official embassy websites or travel advisories is crucial. Biometric verification at borders adds another layer where electronic passports with embedded chips store data like photos and fingerprints, allowing automated kiosks to cross-check against databases. Any inconsistency, such as a hyphenated name on one passport versus unhyphenated on another, or slight variations in birthplace notation, can trigger flags leading to secondary inspection. While this is designed to prevent identity theft, it underscores the need for uniformity in personal data across all documents, which might require legal name changes or affidavits to reconcile. Regarding military service, the concern is real for dual citizens of countries like Israel, South Korea, or Turkey that mandate conscription. A U.S. citizen with such dual status might be required to serve upon visiting, especially males in their 20s, and failure to comply could lead to arrest or travel bans. However, many offer exemptions for those living abroad or who can prove primary allegiance elsewhere, and the U.S. generally does not view basic service as grounds for citizenship loss unless it involves oaths of allegiance that conflict. Consulting embassies early is advised to obtain official deferments or renunciations if desired, though renunciation has permanent implications. For families with dual citizen children, the emphasis is on immediate action, post-birth registering with the U.S. consulate abroad to obtain a consular report of birth abroad, which serves as proof of citizenship enabling passport issuance. Without this, children might later struggle to prove U.S. nationality for college-age Social Security or voting rights. Maintaining consistent spelling of names, dates, and places across birth certificates, passports, and IDs prevents mismatches that technology now readily detects. In summary, these 2026 changes demand proactive steps from dual citizens to ensure compliance, avoid surprises, and fully enjoy the privileges of multiple nationalities. By staying informed through channels like US Visa Portal, you equip yourself with the tools for confident global engagement. As we conclude this in-depth update, remember that knowledge is your greatest asset in an era of heightened scrutiny and interconnected regulations.